Good morning. Today we are going to analyze one problem question on joint tenants and severance. Kindly go through the disclaimer completely. The video content has been made available for informational and educational purpose only. Let's start with the problem question. In 2019, five artists S, T, U, V, and W purchased a house next to the sea. They chose the house because it was isolated and benefited from large windows, providing a ideal condition for them to paint. All five painters contributed whatever they could afford to the cost of buying the house. It was conveyed to all of them as a legal and beneficial joint tenants. At that time, T was only 17-year-old, so he is considered as a minor. In 2020, when Yes grew disillusionized with painting, he agreed to sell his interest in the house to W. A few weeks later, he sold a picture to a gallery in France and decided to carry on trying to making a living as an artist. He persuaded W not to proceed with the sale of his interest and got all others to agree that he could move his son H to live with them in the house. H, who was only 5 years old, had lived with his mother until she died. Yes, doctor had said that living in the seaside house would help H, who has asthma and anxiety. In 2022, T grew bored of painting the sea. He told others he wanted to move to the town to specialize in painting portraits. U expressed an interest in buying T's interest in the house. They discussed a possible purchase price. However, T changed his mind about selling. He mortgaged his interest in the house to Artful Bank to pay for a college course in London to learn how to become a digital artist. T told others that he would not be using the house for some time. Last month, we moved to Amsterdam. Before we left, she painted a note on a blank canvas that was standing on an easel in the artistic studio at the house. Her note explained that she wanted to sell her share without delay. Knowing that T did not visit the house anymore, she texted him the same message. We got an acknowledgement that her text has been delivered to T's telephone. However, T did not read it. He had already left the country because he could not keep up his mortgage repayments to the Artful Bank. U, V, and W have now all agreed that the house should be sold. The Artful Bank also want the house to be sold. However, Yes wants to stay there to paint and he is concerned that a sale would be harmful to H's physical health and mental well being. So we have to advise the co-owners about their respective shares in any proceeds of the sale and whether or not the house will be sold. In 2019, in the initial ownership, the legal estate is held by four of the five artists S, U, V, and W. T is a minor and therefore incapable of holding a legal title. The five artists hold the property as beneficial joint tenants. This means they each have an equal right to possess the whole property and their interest is indivisible. This is likely because they all contributed to the purchase price and the intention was to share the property equally. In 2020, Yes agreement to sell. Yes agreement to sell his interest to W could potentially amount to severance of the joint tenancy. This is because it demonstrates an intention to sever his interest and create a tenancy in common. The potential method of severance here is by mutual agreement. This requires a clear and unequivocal agreement between the joint tenants to sever the joint tenancy. While a written agreement is not strictly necessary for severance by mutual agreement, it is strongly advisable to avoid any ambiguity. If the agreement serves, a yes will hold a one fifth of the share as a tenant in common. 2022, Turner's action. Turner's discussion with you about selling his interest do not constitute severance under any of the common law categories as outlined in Williams versus Hensman case. Simply mentioning the idea of selling is not to demonstrate a clear intention to serve. The discussion with you might be considered a step towards a mutual agreement, but they do not reach the level of a clear and unequivocal agreement. The discussion with you could potentially be considered a course of dealing, but there is no evidence of a consistent pattern of conduct that clearly indicates an intention to sever. A Turner's mortgage on his share is a clear act on his own share, which serves the joint tenancy. This is established in the First National Securities versus Hegate case. This means Turner now holds a one-fifth of the share as a tenant in common. The remaining joint tenancy is now held by other four artists who each have a one-fourth of the share. 2022 Turner's action. This created a separate legal estate in favor of the bank, representing the value of the mortgage. The remaining joint tenancy is reduced to 4/5, with each remaining joint tenants holding a one-fifth of the share. A T's discussion with you about selling his interest do not constitute severance, while there was a potential agreement to sell. It was not finalized. The case law, Williams versus Hensman, particularly emphasized a need for a binding agreement for severance by mutual agreement. 2023 V's notice. V's painted a note on the canvas could potentially be a valid written notice under Section 36 of the Law of the Property Act 1925. A medium of an artist's canvas is likely valid as it is a tangible and permanent medium for communication. While a signature is not strictly required for a valid notice under Section 36, it is advisable for clarity. A V's lack of signature on the canvas is unlikely to invalidate the notice. The case of Harris versus Goddard requires the notice to be in writing and to express the intention to serve, but not necessarily a signature. The most the note must clearly express V's intention to sever the joint tenancy and sell her share. The note has been given to another joint tenants by being displayed in the studio. This is likely sufficient under section now 196.3 of LPA 1925, which allows for the services by leaving a notice at the last known place of abode of the recipient. So the T's absence from the house is not relevant to the validity of the notice. The text message to the T, even though unread, also constitute a valid written notice under the section 36. The notice is deemed served upon delivery and regardless of whether the recipients read it. V's notice is not relevant because T has already served the joint tenancy by mortgaging his share. V's notice would have served a joint tenancy, but this is a moot as a Turner's mortgage already served his share. So, what is a share entitlement in 2023? S and T will get one-fifth of the share as a tenant in common. U, V, and W will get one-fourth of the share as joint tenants. This is the status as of 2023. The decision of whether to sell the house will be determined by the court under section 14 and 15 of the uh, Trust of Land and Appointment of Trustees Act 1996. The court will consider the following non exhaustive list of factors. So, they will look into the wishes of the beneficiaries, the welfare of any minor beneficiaries, and the purpose of which the property is held, the practicality of continuing the joint tenancy, the financial needs of the beneficiaries, for example, in our case, Artful Bank, and the likely effect of the sale on the beneficiaries. The court will consider the relevant case law such as White versus White and Edward versus Lloyd's TSB Bank PLC to guide its decision. The court will balance the competing interest of the co-owners, considering the factors like Yes, desire to stay in the house, and the potential harm to H health against the other co-owners wishes to sell, and the artful bank interest in recovering its debt. What are the legal issues? Right of severance. V's action likely constitute a valid severance of a joint tenancy. Under the Section 36 of LPA 1925, a joint tenant can serve their interest by giving a written notice to other joint tenants. A written notice and message, even if not read by Turner, could be considered the sufficient notice. The rights of creditors. The artful bank, as a secured creditor, has a strong interest in the sale of the property to recover its debt. However, the court will consider the interest of all the parties involved, including the co owners and the H welfare, when deciding whether to order a sale. The Trust of Land and Appointment of Trustees Act 1996 provides a framework for resolving the dispute among the co owners. Section 14 allows any beneficiary to apply to the court for an order regarding the property, including the sale. Section 15 sets out the factors the court must consider when deciding whether to order a sale, including the interest of the beneficiaries, creditors, and the welfare of any children. If the court refuses to order a sale under TLATA 1996, the artful bank could petition for Turner's bankruptcy under the Insolvency Act 1986. This would allow the bank to apply for the sale of the property under the Section 335A of Insolvency Act 1986. Let's conclude. The house is likely to be sold. So majority of the co-owners, U, V, W, and Artful Bank desire the sale. While yes wishes to remain in the house, the court will likely prioritize the interest of mortgagees and the practicality of continuing the joint tenancy. The court may also consider the impact of H welfare, but this is unlikely to outweigh the other factors. Thank you.